Ms. Parkin.
Good afternoon. Just turning first to pick up a point raised by my Lord Justice Henderson before we rose. All of the figures set out in those spreadsheets, and we've now, by the way, put a larger A3 version of the spreadsheets in front of the court. It doesn't have to strain its eyes too much. All of the figures are contained in they're all audited, statutorily audited figures. They are all accounted for in the relevant corporate entities' accounts. So where one sees costs incurred by FCCW and income generated by FCCW, that will be found within the FCCW accounts. Although it's fair to say it won't be identified on a contract-by-contract basis, but the figure will be there. And that is correct, not just for the costs of things like manpower, site, etc., etc. That's also correct for the overhead allocation as well.
The overheads being calculated on some kind of apportionment basis.
Yes,
right?
absolutely. Well, yes, absolutely. We'll come to look at the evidence on the overheads in a moment and precisely how that works. But yes, it's done as a percentage of individual entities' turnover, and the overheads represent the costs to individual entities like FCCW or FCCR using the facilities of the head office.
Yes.
In a way that we're just going to look at in a moment.
Well, that certainly all sounds very sensible, although the test, of course, is a rather different one. I mean, the basic test for deductibility in a computation of profits is whether the expenditure is wholly and exclusively incurred.
Absolutely.
For the purposes of the trade. It's not quite the same as the wording we have to construe here.
I understand that, my lord. I do understand that.
I don't want to take us down an irrelevant rabbit hole. There might be some peripheral relevance. Just pausing there for a moment then, we're going to return back to look at North London. We were in that contract just before lunch and I identified various specific obligations, for example, to provide staff, to provide equipment. There were other more general obligations like providing health and safety.
Meaning we should get out of the contract?
No, I'm going to try to fast forward. Yes. I'm just going to give you some references, my lord. But there were, we looked at some of those general obligations before lunch, things like arranging rail licences, etc., etc. There were similar health and safety obligations, obligations to attend meetings and publish reports, and those are the sorts of services that were effectively provided by head office and then recouped in relation to the overheads. Just before turning to look at what the judge concluded, and thinking about those items of cost that we looked at in that big spreadsheet before lunch by reference to the income which North London is paying FCCW, one might ask, how are costs like manpower and equipment not directly incurred costs in the generation of the North London revenue? And in my respectful submission, it is clear when one looks at the services that were to be provided to North London, in return for which the sum was being paid by North London, it is clear that things like manpower, site costs, hire costs, fuel costs, plant repair and maintenance costs were costs which were directly incurred in order to generate the North London revenue. And the reason for that is, if FCCW did not put the staff on the ground to take the waste from the train and put it into the tipper truck, it would not arrive at Greatmoor in the first place. So that one might say is the way in which, if one were looking at this contract and thinking about these costs, how one might ordinarily and naturally assume or conclude that these costs related to the income. The learned judge, however, concluded that these costs were not directly incurred in the generation of the income. And his reasons for doing so can be found initially at paragraphs 198 to 210 of his judgment,
And then latterly, in particular in relation to manpower costs, at 244 to 252 of his judgment.
I mean, just jumping ahead, he doesn't say if you can show that a cost was incurred in manpower in doing a particular thing in this exercise, it isn't directly incurred. He says, I can't tell.
No, he doesn't, my lord. And that's why one needs to start at the beginning. He says he can't tell by reference to the test that he identifies in determining what directly incurred means. And that's why I break his judgment down into two parts.
Okay, but we haven't yet seen any evidence about what costs were incurred.
Well, my lord, that's because it was all dealt with in the sampling protocol process.
Well, that tells you what costs were incurred overall. It doesn't tell you anything about what they were incurred on. And we haven't yet seen any evidence about what the costs were incurred on.
In what sense, my lord? Because I've explained to your lordship how there are, for example, the way in which the accounting system works is that all of these costs, so when the men are employed, so for example, there are contracts which
so
are...
where is the evidence about this?
It was all provided, it's all in disclosure, my lord, it's all in the trial bundle.
I mean, I'm taking you out of your course, but what we do see is in the witness statement of Mr. Mackenzie...
Yes, my lord.
Where he says 8.8, for example, at 577, in the second supplemental bundle. 8.8.2, manpower. This includes wages, strict salaries, national insurance, pension costs, blah, blah, blah. Well, where does he explain how much of that figure is attributed to any particular activity?
My lord, if your lordship were to go on to page 579...
Yep.
One sees, for example, Mr. Mackenzie's specific evidence in relation to North London.
So where does he say how much of all the manpower costs is attributable to any particular activity?
Well, it was all attributable. In the case of the North London contract, it was all attributable to the North London contract. And the reason for that, my lord, if your lordship were to read on at paragraph 819 to 820 and 821, what your lordship sees...
paragraphs.
Start at 579, manpower.
Yeah.
BC said it cannot reconcile the values of the costs shown in the calculation of the manpower costs associated with the operation of the NLWA contract with the documents disclosed. So what had happened during the sampling protocol is that BC had requested copies of timesheets which detailed what these men were actually doing and how long they spent in relation to the North London contract. They were provided with those timesheets. They were also provided with the contracts of employment for those people in relation to which the basic functions of the staff were there identified. So it would, for example, say tipper driver or equipment handler or whatever. So it was provided with all of that information, and it was provided with all of that for all of the underlying contracts. It then concluded or wrote to my client's solicitors, Vincent Mason's, and it said, we accept that the documents that you have shown us and we've chosen to see support the figures that you say you incurred for manpower in relation to providing services for Herts, Luton, well, not Luton, but Herts and North London. It raised an exception about the North London manpower. It said we can't reconcile some figures. And this, at paragraph 819, is Mr. Mackenzie's evidence about what that manpower figure that we looked at earlier shows. And my lord, what he says is, effectively, that they, when the EFW, the Calvert NLWA TS cost centre, that's the cost centre from which all of those manpower, those costs that we looked at earlier are recorded, did not exist immediately after the EFW went into service. The waste from the railhead historically went into the landfill.
When the EFW went into service, it was decided to transport the waste up from the railhead to the EFW. This involved the people who were employed to work at the landfill. We created a new cost centre for the transfer station operation. We experienced administrative problems getting the people's payroll costs allocated to the new cost centre. It was evident when we prepared the additional TPI calculations that the manpower costs recorded in the transfer station cost centre were too low. The management accountant preparing the additional TPI calculations then sought out all the names of the people who worked at the transfer station, moving the waste from the railheads to the EFW. She then also sought all their payroll costs over the relevant time periods. With this information, she was then able to reconstruct what the manpower costs should have been recorded in the cost centre P&L account, and then use those costs in the additional TPI calculations. What you see in the detailed data read cost centre names of where the employees were incorrectly allocated by the payroll system. BC is attempting to use that fact to suggest that, in fact, the costs are not relevant to the transfer operation. That is not this case. Now, just for your Lordship's note, the learned judge accepted this evidence and accepted that the North London manpower costs were effectively incurred by FCCW in this case. And one sees that, my Lord, at paragraph 254 of the judgment, where the judge says, and that's at page 131 of tab 10 of the core bundle, there is a separate issue in relation to manpower where there is a dispute between the parties about the proper assessment of that amount, i.e. the amount which FCC had included in relation to North London. Given my conclusions, I do not need to address it, and those are the conclusions that we'll come to look at in a moment. In case of any appeal, I will do so, nevertheless do so, briefly and for completeness. In short, having regard to the evidence of Miss Boozy and Mr Mackenzie on this point, as summarised in FCC's written closing submissions, I am satisfied that FCC would have satisfied the burden of proof in relation to this item.
Yeah.
So, my Lord, if I may, just coming back.
Yes.
Sorry, my Lord. So what the learned judge does is he deals with principles first of all, and he deals with how one should construe directly incurred, and then the provisos in the first part of his judgment. And having arrived at a construction of directly incurred, he then goes on to apply his construction to each of these heads of cost, which is why when I said to your Lordship a moment or two ago, you've got to start at the beginning before one looks at the evidential requirements. Why I say that? Because what he's doing in relation to the evidence is applying the test that he finds earlier. And that test starts, my Lords, at paragraph 198, and that is in the bundle at page 121, tab 10 of the first core bundle. And it runs from 198 to 210. What I'm going to do is just summarise what I understand the judge to be saying. He starts off by saying that the words directly incurred should be given their normal meaning. That's paragraph 198. He then says at paragraph 199, adopting the submissions of my learned friend, that directly connoted in some immediate relationship between the winning of the income and the outlay. And again, we would say, so far so good, and I've attempted to show the court before the short adjournment how there is that immediate relationship here, given the nature of the services to be provided and the income that arose from those services. He then turns at paragraph 201 to consider the Streetworks Recovery of Costs Regulations 2002, which he says utilises the term direct costs, and he says that he regards that as helpful because he says that the Streetworks regulations provides some support for the general understanding and approach which most lawyers, accountants and business people would share if they were asked to think about what direct costs are, in comparison to such things as indirect costs, fixed costs or overheads in the context of costs incurred by a medium or large-sized business, such as the FCC Group, which operates through a number of companies. Now, just pausing there, my lords, and noting that although the Street Works regulations do in fact use the term direct costs, that is not a term that is used in the definition of third-party income, which instead says that the contractor shall be entitled to deduct from such income the costs directly incurred in generating the income. And what the learned judge does by inserting the word direct, so his construction is, shall be entitled to deduct from such income the direct costs directly incurred in generating the income, is he introduces a proviso which is simply not in the words that the definition uses. He then goes on to note at paragraph 203 that the dividing line lies between the costs which are incurred specifically in relation to the particular income generating activity and the costs which are incurred by the organisation as part and parcel of undertaking its activities as a whole. Now, again, just pausing there and thinking about how that might work in the context of this case. In our respectful submission, there is no reason in principle why costs incurred by an organisation as part and parcel of undertaking its activities as a whole cannot be costs which are directly incurred in order to generate income from a third party. Indeed, we say 9 times out of 10, that will be exactly how the income is generated. A company will use its existing resources to service a new contract.
So what do you say directly incurred does mean?
What it means, my lord, is that you are looking for the causal relationship between the income and the costs. What costs have been incurred in order to generate that income? Directly incurred is not limiting the type of cost which is recoverable. It's talking about the causal connection.
So suppose that in order to generate income of £10, you actually need your head office building.
Mm-hmm.
And the head office building costs £1 million a year to run. You can net off the whole of the £1 million against the £10.
That is not how we say this clause works, my lord. No, we don't say it works like that at all. What we say, just turning to the particular facts of this case, if you remember looking at that spreadsheet this morning with all of those costs lined up, the manpower costs, let's take those because they're the easiest ones to sort of comprehend in terms of how it might work. If you need 4 people to load the trucks from the train and drive the trucks up to the gate of Greatmoor, the suggestion that those costs are not directly incurred to generate the income is, in our submission, simply wrong.
So the trouble is, on the judge's test, they might be all right, as I understand it.
Well, no, for this reason. We'll come back to that in a minute.
You're saying if to generate any particular item of income, you need something else, the whole of the costs of the something else can be put down?
Yes, in terms of North London, yes. Because
No, not in terms of North London. I want to understand the test.
No.
Is it your proposition that if, in order to generate any £1 of income, you need something else, the whole of the costs of the something else can be put down?
It depends what the whole of the cost of the something else is, my lord.
Well, on the causal test, do you mean anything that you need is deductible?
No, my lord. Well, not in the way we say that's applied in terms of it depends upon the nature of the income generated. So North London is a particularly straightforward example, we would say.
Well, possibly, but I'd like to understand what the test is on your case.
I'm aware, my lord. In the case of North London, yes, where you are incurring manpower costs, which are only ever incurred because of the North London contract, then yes, that is a cost which is directly incurred.
But that doesn't tell you anything, because I'm not sure that's inconsistent with the judge's test.
Well, it is, my lord, because he doesn't allow us to recover these.
Well, he doesn't on the facts, but he isn't saying if you have to employ someone to do a particular thing and he is doing it only for the purpose of that thing, you can't recover it. He doesn't say that at all.
He does, my lord.
Where does he say?
Well, he says it, my lord. If you look at 208. Unless FCC had actually scaled up its costs of operating a particular facility or service in order to deal with the TPW in question, it would not have incurred any actual expenditure on these fixed costs.
Right. So if you have a case where you employ someone for the purposes of the North London contract or any other contract in order to do a particular thing for the purpose of that contract, that's fine.
But that's what has happened here.
Well, that may or may not be
North
what's
London
happened, but
contract.
that's not inconsistent with the judge's test. The judge is saying, if that isn't the case, if you're not incurring any extra expense,
Well, let's look at
then
it.
that's not all right.
Well, let's look at it in how in terms it works with the income generated from the Hertfordshire contracts.
Well, I'm still not clear what the test is.
Well, in my respectful submission, in terms of North London and in terms of all of those costs, which the judge has said we cannot recover, and it's not clear why we can't recover them, is what I'm trying to say to you, my lord, because actually these are all costs associated
And
with
if
North
you're
London.
right about that on the evidence, well, fine. But then you're not saying the judge is wrong in his test, as far as I can
Well,
see.
that's why I'm turning to the Hertfordshire contract, because I'm going to explain to your lordship how this test works in relation to the Hertfordshire contract. And the reason that I've taken North London, so as I
The
explained,
test I should write down, sorry, I'd just like to be clear. So the test I should write down is any cost you incur in relation to something that is needed to generate an item of income is directly incurred.
but for the incurring of these costs, the income would not have been generated.
And so that really could apply very often to all or most overheads, which are shared between different
well,
aspects of the business.
Indeed, my lord, it could. It's not actually what has happened here.
Is it the test you're at odds with, so far as the judge is concerned, or is it the application of the test?
Well,
for the
in a moment,
particular
in a moment, my
contract?
lord, if I can come to show you what happens in relation to Hertfordshire, you will see it's also the test. And you'll see why it's the test when you come to understand how the income arriving from Hertfordshire isn't just one fee like it is with North London. In Hertfordshire, what happens is that we're retained to operate a transfer station for Hertfordshire. At that, and those are the Hitchin and Stevenage and Waterdale sites that I showed you earlier on the map. At that transfer station, Hertfordshire sends its municipal waste to the transfer station. So coming in is Hert's waste. Going out is waste, some waste that goes to Greatmore, some waste that might go to recycling, some waste that might go to another treatment facility altogether. As a result of the O'Farrell judgment in the Part 8 proceedings, FCCB was obliged to account for the portion of the income that it received from the Herts transfer, operating the Herts transfer stations, which represented the volume of waste that goes out to Great Moor. So if it receives £100,000 from Herts and 50% of the waste ends up in Great Moor, 50% of that income has been allocated to the third-party income provisions. And what FCC has done in those circumstances is to say, because you've had 50% of the income I make, I wish to deduct 50% of the costs that I spend in operating the Herts transfer station. And that is where paragraph 208 of the judgment kicks in. So what the judge has said is, because you, FCC, cannot identify that you've employed another person to operate Herts, you can't show that you've scaled up your costs in order to deal with TPW. So you can't have any of those costs. Because in the judge's view of the world, they are fixed costs which FCCW would always have incurred. And because their fixed costs are not direct costs, they're not recoverable.
So is the judge's test effectively saying it's a marginal cost principle which has to be applied? In other words, you can only get it if you, as he put it, had to scale up your operation in some separate identifiable way in order to generate this.
Yes.
Which your answer is, you say, well, that's not necessary or appropriate to go that far because you're using a part of your existing apparatus in order to generate these particular costs, and the answer is therefore to do an appropriate apportionment.
Absolutely, or looked at again in the context, in the way in which the waste industry operates. If I am required to operate a treatment facility for another waste disposal authority, Herts in this case, I employ 20 people in order to operate that facility for Hertfordshire, i.e. in order to treat Hertfordshire's waste. As matters transpire, 50% of that waste goes to Great Moor. But because I can't show you that I employed 21 people, I can't recover any cost at all. And that's why I was at pains to stress this morning the importance of the connection between the cost and the nature of the income that is being accounted for in a TPI calculation. Because if you're just accounting for a proportion of the Herts waste, on the judge's test, you're never ever going to be able to deduct costs, because you will never show that another sum has been incurred. And in those circumstances, what's happening is you're just allowing the Buckinghamshire to take the gross revenue which you are generating from servicing Hertfordshire, or the relevant proportion of the gross revenue.
Yeah, and on the judge's approach, I don't think it's right to say you could never get anything. You would have to get over the very high hurdle of showing you've incurred some extra special marginal additional cost.
Well, with respect, my lord, that's not right, really, because if one thinks about what one's doing when one's servicing the Hertfordshire contract, Hertfordshire says, I'm delivering 100,000 tonnes of waste to this waste treatment centre, and I want you to manage the waste treatment centre for it. You're going to staff that contract always to deal with the 100,000 tonnes because that's what Hertfordshire wants you to do. So your staffing costs are always going to be limited by what Hertfordshire wants you to do. As it happens, Greatmore is just a subset of the Hertfordshire costs. So you're never going to be able to show that there was more because it's always part of something bigger.
So you're just focusing on the relationship between the costs as incurred and the achievement of the particular purpose for which they've been incurred, and you say that's enough to get over that particular hurdle. You'll then have to satisfy the three provisos as well.
Absolutely, and we'll come to look at
At least
those.
you're then over stage one.
Yes.
And it can't be knocked out at stage one on the basis that the judge did, because he's adopting a test which, as you say, seems, well, I think this is how you put it, which is anyway, is in practice going to be impossible to satisfy.
In practice, this will be an impossible test to meet.
And that's something the parties objectively couldn't sensibly have intended when they entered into the agreement, not least given the background you explained to us this morning.
Absolutely, my lord, and we will come to look at some of the underlying contractual documents. Sorry, Widdop and what Widdop says a little later on when we look at the provisos. But the purpose of the third-party income sharing regime, we say, as is clear from Widdop, is to effectively share what Widdop describes as net revenue, which it means net of costs.
I'm going to take you out of your course again, because as I understand it, the standard form Widdop material is at tab 33 in the supplemental bundle, is it?
Yes, my lord, yes.
And that uses the term marginal costs.
Oh, so sorry, my lord. It's not. It's just give me a second, my lord. It's not. It is. Oh yes, it is the tab 33. Yes, it does. Yes.
And if it were a marginal cost test, well, that's more or less what the judge says.
But marginal costs in relation to what?
Marginal costs of generating such income. So the
Again,
extra costs of generating
the extra costs of generating, but one has to think about, and we'll come to look at this when we come to look at the provisos, how they work in relation to the additional costs.
But isn't this more or less the judge's approach? He says it has to be extra cost. It's marginal cost.
But that comes back, my lord, to actually thinking about how that works in an apportionment situation.
I can see the problem with apportionment, but I wonder if that's a slightly different problem.
Well, let's look at, for example, let's look at the FCCW costs for for North London, which are the costs that we've been looking at this morning. Those are not costs which any of the parties to the PA incur at all. So what you're doing is you're taking income which is not dealt with in the PA at all, for the reasons that we looked at this morning, and you're looking at a set of costs which is not dealt with in the PA at all either. So there are these two sorts of problems with in my respect for submission. The first arises when, effectively at 208, what the judge says is you have to identify some additional cost, where you scale up running a facility in order to treat waste that goes to Greatmore. We say that will never, on something like Herts, that will never happen. On something like North London, it has happened because all of these costs are referable to North London.
With the Herts problem, I don't know, but perhaps there's a slightly different way of looking at it, which is it was necessary to. You say, well, the point is a share of the Herts income is attributed to you. Mm-hmm. So one might possibly think, well, a matching share of the cost should be attributed. Mm-hmm. But might that be on the basis that you have to look at the costs incurred in producing the totality of what you are then apportioning.
Yes, my lord, that's exactly how.
I'm not quite sure that's different from what the judge was saying.
No, it is, my lord. What he's saying is you have to identify actually scaling up your costs. So he doesn't allow us to recover the Herts manpower fees, for example. And I'm using manpower because that's what the judge does, and then everything else cascades down. So I'm going to stick with manpower. If you think about Herts, there will be, let's say, 10 people employed to run the transfer station for Hertfordshire in order to deal with the Hertfordshire waste. As it happens, 50% of the waste goes to Great Moor, and they get 50% of the, we're accounting for 50% of the income we receive from Hertfordshire in the TPI calculations to Buckinghamshire. Now, of course, in one sense, one might say, actually, the 50%, you couldn't have sent any of the 50% to Buckinghamshire unless you'd incurred all of the costs in dealing with Hertfordshire. That is a perfectly possible causal route through this. But that's not what FCC has done in its calculations. Because if one thinks about it, one is left with three alternatives. Alternative one is share 50% of the income and deduct all of the cost. Alternative two is share 50% of the income and deduct none of the costs. Alternative three is share 50% of the income and deduct 50% of the costs. And the judge has gone for alternative two. And in our respectful submission, the difficulty with that is you would always fail that hurdle. There would never be any costs recoverable where you were sending waste from a waste transfer station like Herts to Great Moor. And one can look at it and ask oneself, why does the judge conclude that haulage income is recoverable? Because you might say that all of the waste is going out of Hertfordshire, the waste transfer station in Hertfordshire, and it would always all have to go out of the Hertfordshire waste transfer station. But the judge concludes that haulage is a directly incurred cost. And so we say that that's a fundamental problem with the test as he describes it. And because he says, I have to identify some extra over cost, he then concludes, when he goes on to look at the evidence, to say on the evidence, FCC hasn't identified any extra over costs. Now, in relation to North London, to Hertfordshire, as a matter of fact, he's right, because there never would be any. But in relation to North London, where all of the costs are referable to all of the waste going to Great Moor, it's hard to see how those could not be directly incurred in the but-for sense that I describe it. So in a nutshell, that is our case on directly incurred. The judge took the words in the regulations which were not the words used in the definition, and then fashioned for himself out of those words a test which, when applied in relation to the industry in which these parties operate, produces a solution that, in my respectful submission, no commercially sensible parties could have contemplated. Unless I can assist your lordships any further on directly incurred, can I move on to the provisos, my lords? My learned friends say that even if I persuade your lordships on the directly incurred point, the judge was wrong to find that these costs met the provisos and should have thrown them out on the provisos basis. I'm going to start with some general propositions about the provisos, and then I'm going to move to look at each of these provisos one by one. Firstly, in terms of where the judge concludes that the provisos were met, it's paragraph 219, where the judge concludes that these costs were specifically and solely referable to the generation of third-party income, in addition to that shown in the base case. And just pausing there, my lords, and coming back to the discussion that we've just had, it's quite hard to see how one can conclude that these are specifically and solely related to additional income generation and then conclude that they're not directly incurred. So 219 is his conclusion on proviso A. 222 is his conclusion on proviso B, where he says that we have been able to demonstrate that they're incremental costs over and above those envisaged in the base case or recovered through the payment mechanism. And 240 is his conclusion in relation to proviso C, where these are that we have demonstrated that these are not the costs of handling and processing the third-party waste. So, some general propositions. Firstly, then, one comes to looking at the provisos. Firstly, having identified the type of TPI with which we're concerned, which subparagraph of paragraph 11 is engaged here. 11.2, 11.3, 11.4 or 11.5, and we'll come back to look at those shortly. So the first question for the court is, what type of TPI am I dealing with? And we say, it's clear when one reads these provisos that it must be TPI under subparagraph 11.5, other third-party income. Secondly, you only get to the provisos if you have concluded that the costs were directly incurred in generating the income in question. And thirdly, it's entirely possible that different provisos might operate to cut out income under different heads of the TPI regime. So, for example, one could find when one goes through the formula in paragraph 11 that the costs meet provisos A and B, but they get kicked out on proviso C, and I'll explain how that works shortly. The reason why we say that the correct categorisation is important is that where excess TPI is of a type that has already been modelled in the base case, then obviously there will be questions about what costs were included in the base case in relation to that excess TPI. different analysis, we say, applies when you are dealing with other excess TPI. That's the clause 11.5 TPI. My lord, it might be worth just pulling up at the moment the PayMec itself, which is in the core bundle, tab 33, and the relevant pages are 102.3 to 102.5. And one can see there a difference in the sort of calculations required, for example, under 11.3 and 11.4, where what is required is the taking out of guaranteed third-party income. Under 11.3, one can see that in terms of the guaranteed electricity third-party income. And again, one can see it under 11.4, where one is taking out the GTPW TPI, the guaranteed third-party waste third-party income, that being the 182,000 times £66.50. And then if one turns over the page at 1025 and looks at other excess TPI share, nothing is coming out there, because as I indicated to the court this morning, nothing else was modelled. And so, as I said a moment or two ago, when you've got income in the base case, of course you're going to be concerned to understand what costs might be in the base case in order which are referable to that income. My lords, the provisos, we say, are not unambiguous. There are many circumstances in which one could establish that, but perhaps the easiest way is to look at provisos A and B, which the court will see at page 848 of the bundle, the definitions there, where both refer to the costs to be taken into account. Is that a reference to the costs incurred by FCCB as the SPV? Which I showed the court this morning in that financials tab. Or is it instead a reference to the costs incurred by FCCR as the O&M contractor performing the services under the O&M agreement? Both are possible. I'm going to look at what we say the right construction is, but the point of this submission, my lords, is to emphasise that these are not straightforward provisos where one simply looks at the words and carries on regardless. And so the ambiguities inherent in the language used in the provisos, we say, means that the court has got to be alive to both the commercial purpose of the clauses and to the commercial consequences of the rival constructions contended for. And as the court knows from this morning, we say in those circumstances regard should be had to WIDIP. And I'm just going to give the court a note. It's in the supplemental bundle, tab 32, page 839. My Lords, this is in the guidance document.
Yep.
And at 839 all the way through to 842 is the WIDIP guidance about third-party income provisions. And, my Lords, one will see that this is about, from 2.6.1, the sharing of the financial benefit that arises if income is in excess of that anticipated. 2.6.2, the third-party income sharing mechanism should be structured to allow the authority to share in net revenues from specific process outputs where the net revenue exceeds an agreed predefined threshold. So two things there. Net revenue, and also, my Lords, we do put some importance when one comes to look at Luton on the word specific process outputs. What WIDIP envisages, and one can see that, I don't have the time to go through it, but one can see that it envisages things that come out of the facilities, i.e. if you've got spare treatment capacity, as a result, that's something which is inherent within the facilities. And one sees that at 2.6.3 over the page at page 840, where it's talking about income from sale of such spare capacity. And then again at 2.6.4, electricity and heat related sales, i.e. that's the electricity or other product generated by the treatment facility in question. And then 2.6.5, sales of other process outputs. And one sees, if one looks down there, that includes recyclable materials, compost, CLO, recycled bottom ash, etc. And just for the court's note, recycled bottom ash was something that came out of this particular treatment facility. Essentially, it's the stuff that's left after one burns the waste. So essentially, that's the background to the provisos. Proviso A.
Just to be clear, when you talk about net revenue, presumably they had in mind net revenue using the third-party income definition or something similar, such as we see at 845.
They do, my Lord, but they have it in mind by reference to process outputs. And one can see how, actually, if what one's talking about is things that come out of the facility, like electricity, like bottom ash, like the sale of the spare treatment capacity, of course that makes sense because it's that form of revenue.
So can I be clear? I mean, of course, they didn't ultimately use the marginal cost formula in our case.
No.
But you say it makes sense to think of marginal costs given the sorts of output.
Yes. So let's take our case and electricity. If you generate more electricity and sell the electricity for sums which are greater than you have guaranteed under the guaranteed income regime, then clearly, because you've already included for some of those costs in the base case,
it makes sense to talk about marginal costs. Because what you're trying to prevent is the contractor recovering costs that he's already included in his base case, and so therefore have already been taken account of in the cost to the authority in treating its waste. Coming back.
Just, you say in relation to electricity, but obviously the guidance document also deals with third-party waste.
It does, my lord, and we can actually test how that might work in relation to third-party waste here, and if it's helpful, I can do that right now for your lordship. Third-party waste, my lord. It starts off. One needs to look at 1024, which is the provisions for third-party waste excess TPI share, WTPI. Now, in my respectful submission, what 11.4 is directed at is the accounting for additional gate fee income, i.e. income received from the sale of the spare treatment capacity. And there are a number of pointers to that, my lord. And the first is in the definition of TPWR, the excess third-party waste, third-party income derived from gate fee revenue over and above the guaranteed third-party waste, third-party income. What you're seeking to identify is the difference between that sum which was guaranteed, which, as we saw this morning, was the gate fee for 182,500 tonnes of waste. If you generate more income from the gate fee from that, that is to be shared under paragraph 11.4. Now, pausing there and asking oneself, if more income had been generated under 11.4, what costs would the contractor have been entitled to deduct from that income? Firstly, the question is, what costs the contractor, the SPV, incurred? Actually, the only cost that the contractor, the SPV, incurred is the payment of more money to the operations and maintenance contractor, FCCR, via the operation of the O&M payment, which we looked at earlier. And so, my lord, in this case, if your lordship were to have open the O&M PayMec tab, at tab 4 of that small bundle that we handled up very first thing this morning, one can see that, we can see from this document which we looked at this morning, that the base case is calculated on us paying the O&M contractor to treat 282,500 tonnes of waste. If the contractor in fact treats more than that, then obviously we, SPV, will incur the additional costs
at a rate of £9.24 per additional tonne.
Yeah.
So in those circumstances, the additional costs directly incurred by the contractor in order to generate the excess income is that £9.24 times by whatever the excess tonnage is. So just turning to think about how that works under the provisos. Would it meet, for example, proviso A, which is at the bundle tab 848? Would the SPV be able to demonstrate that the costs are specifically and solely related to the generation of TPI additional to that modelled in the base case? We say yes, it would. Because the base case is modelled on paying only for 292,000 tonnes, 82,000 tonnes. Would those costs meet proviso B? I.e., would they be incremental costs over and above those costs which were either envisaged in the base case or have been or will be otherwise recovered through the payment mechanism? Yes, we say they would be incremental costs, because again, the base case is predicated on a lower tonnage. What about proviso C? Are these costs of handling or processing the third-party waste by the contractor or affiliate? Well, we would fall at that hurdle because, yes, they would be costs of handling or processing the third-party waste by FCCR. And so in those circumstances, I would not be able to deduct the increased amount that I've actually paid to my O&M contractor. That's the way these provisos work in relation to clause 11.4 of this contract. That makes perfect sense, where what one is dealing with is the additional gate fee income. Because one can see how the base case feeds into the operation of the provisos. We're not dealing with additional income of the sort that we are concerned with.
Just to be clear, you've taken us through all that by reference to the SPV.
Yes.
And do you say that's the right way to look at it?
I do, my lord, and the reason that I say it's the right way to look at it, because if one looks at 11.4,
Yep.
At page 1024, it talks about income received by the contractor.
Yes, I see.
So that might be a conventional way we say that all of the provisos would operate in this particular circumstance. It's also an answer in our respectful submission to the case which is put against me, which is that my construction means that proviso C is surplus to requirements. It might well be surplus to requirements when one goes through some of these exercises under paragraph 11. But it's clearly not surplus to requirement in this case, because it's the thing that actually kicks in to prevent us from deducting the costs. And my lord, just as a matter of fact, in fact, this facility did process more than the 292,000 tonnes that the base case was predicated on. In some years with which your lordship is concerned, it actually processed over 300,000 tonnes of waste. And in those years, FCCB
deducted no costs before accounting for the income under clause 11.4. What we're concerned with in this case is a different type of income, which is why at the outset I was so keen to stress to the bench it always depends on which provision and part of clause 11, paragraph 11.1 is operating in. The type of income with which the judge was concerned was income from hauling waste to the facilities, and income which FCCW received from operating the facilities. By this, when I say the facilities, I mean Herts, North London, in a way in which we've just the outside of Bucks facilities, if I can put it in those terms.
And I'm afraid I can't remember Mrs. Justice Farrell's judgment properly. What is brought into account on the basis of Mrs. Justice Farrell's judgment? Is it the income received by FCC B or the income received by FCC R or W?
It's the income received by FCCW in its role as haulage contractor for Hertfordshire and in its role as haulage contractor for North London. It's the income received by FCCW in its role as manager and operator of the Hertfordshire transfer stations. And it's that additional slice of the income. Do you remember this morning when I showed you the difference in the NLWA contracts between the amount that W receives from NLWA and has to pay to R? It's that other little slice.
So that's received by FCCR?
No, it's received by FCCW.
Oh, I see. I see, yes, I see.
Yeah, because
the
of
difference between the lesser amount
absolutely.
that pays on, yes,
One has to remember one's contractual
Yes.
chains.
Yep. Yep.
And in my respectful submission, all of those categories of income are other excess TPI share, because they are not gate fee income received at Greatmore. When one starts from that basis and then one starts to apply the provisos, one sees, I hope, the force in the submission that I made right at the beginning, which is it is important to identify what type of third-party income it is, because the provisos will operate very differently where the income is not of a type that was modelled in the base case. And so very quickly, just testing this by reference to the haulage income. And the costs one might incur in hauling. Would the contractor be able to demonstrate that the costs of hauling to be taken into account are specifically and solely related to the generation of TPI additional to that modelled in the base case? Yes, because no haulage income was modelled in the base case. And by that I mean haulage income from outside of Buckinghamshire to Greatmore. Proviso B, would the contractor be able to demonstrate that these are incremental costs, either over and above those costs which were envisaged in the base case
or have been or will be otherwise recovered through the payment mechanism? Answer, yes. The base case contained no costs for hauling waste to the facilities. And so no such costs will be recovered through the payment mechanism. Proviso C, would the contractor be able to demonstrate that the costs are not the costs of handling and processing the third-party waste by the contractor or affiliate? Answer, yes. Now, I have to deal with one further point in terms of Proviso C.
So you say the further point. What's the first point? That you're not within C because
The cost of hauling the waste from Hertfordshire or Hendon
yes,
to the Calvert train station, for example, in the case of
yes,
North London, are not the costs of handling or processing the third-party waste. And the reason for that, my lord, is that third-party waste is a defined term, and your lordship will see that in the bundle at page 849. Third-party waste means all waste received at the facilities other than contract waste and substitute waste. And so we say Proviso C is, by definition, limited to the cost of handling and processing at the facilities.
So why does it have to be at the facility rather than in
Well, because,
handling
my
it
lord,
by taking it to the facility?
because if one thinks about the way in which the cost basis of this contract is structured, the base case contains all of the costs of operating and running these facilities and shows one the income sources and the costs incurred by the SPV in operating and running these facilities. There is nothing in the base case which takes one outside the realms of the facilities.
Yeah, thank you.
And nor is there any commercial purpose in extending Proviso C to prevent recovery of costs incurred outside of the facilities.
Can I just understand what we think C is there for? I mean, I'm not sure that the WIPIC or whatever it's called draft really matters, but that talked about marginal costs. And in one sense, this is an elaboration on marginal costs, the totality of the definition of third-party income. And so it's taking out costs that aren't directly incurred, whatever that means. It's taking out costs that aren't specifically and solely related to extra income. It's taking out costs that aren't additional to costs that are already in there. And then you've got C at the end. I don't quite follow why C is there.
Well, it's there, my lord, because of the exercise we went through with paragraph 11.4. So if you remember, when we went through the gate fee, additional gate fee income, in my submission I said that where the SPV incurs additional costs in paying the O&M contractor, they would meet Proviso A, they would meet Proviso B, but they wouldn't meet Proviso C because those would be the costs of handling and processing the third-party waste by, in this case, the affiliate. So it's again a sort of a recognition of the fact, again, that what one is talking about is what happens within the confines of the facilities. And that the O&M contractor had been retained to process all waste that came into the facilities.
not just the contract waste.
Were there no costs built into the base costs that for haulage into the facilities themselves?
Not into the facilities, no, my lord, no. So there was costs which were related to the haulage between High Heavens, that transfer station, and up to Great Moor, but there were no costs that were related to the haulage into the facilities. And the reason for that, in my respectful submission, is at the point in time that the base case was created, the parties would have no idea where that third-party waste was coming from. And so, for example, in today's world, it's being hauled to the facilities by other contractors who incur that cost themselves. I just need to deal very quickly with one other point raised in relation to Proviso C before I'm going to turn quickly to deal with Luton, which is my ground two. Yep. And that is the point which is made against me, which is that my construction, says my learned friend, results in us being incurring the cost once but being paid twice. And he makes that point in paragraphs 120 to 121 of his skeleton, which the court is going to find at tab 40 of the bundle, page 1135 to 1136. And that argument is relied on quite strongly by my learned friends to say that the judge got the construction of Proviso C wrong. It said on FCCB's case, this is paragraph 120, it only incurs the cost of hauling the waste from a WTS to Great Moor once, but is compensated for that haulage cost twice. Now, just pausing there and thinking about how that works in relation to this contract. As it happens, FCCB, the SPV, does not incur any costs of hauling waste to Great Moor, because it's retained the O&M contractor, FCCR, to do all of that. FCCB simply makes a composite payment to FCCR for all of the services which FCCR performs on a cost per tonne basis. And we saw that when we looked at the O&M payment. It also doesn't incur any of the costs of hauling the waste from, for example, Hendon to the rail station close to Great Moor, because those are the costs incurred by FCCW. So in fact, FCCB doesn't incur the costs at all. It also does not incur the income from hauling waste from Hendon to Great Moor, because as we saw, that too is income which is paid to FCCW. So that submission, in my respectful submission, is a non-starter. And so, for all of those reasons, my lord,
just to be clear, it doesn't play out further down the structure. How does it work from the FCCW point of view?
FCCW holds on to the income it generates from haulage, because the only thing FCCW pays to FCCR is that gate fee, and that's under the contract that we saw at tab 11 of the supplemental bundle.
Yeah.
And FCCW is the organisation which incurs the costs of haulage,
And those are not, that they just sit with FCCW.
Yeah. Yeah.
So that's directly incurred, and that's the provisos dealt with both from the perspective of why we say the judge was right and also why my learned friend is wrong in relation to his appeal about haulage. Next, I would like to deal with Luton income, which is ground 2 of my appeal. Yes. And again, I'm going to start with what I hope is common ground. The contract with Luton was concluded in 2004. That's 9 years before the PA. At that point, FCCR was retained to provide waste management services and undertook to carry out related construction activities for the London Borough of Luton. The overall objective of the Luton contract was set out in the specification. And my lords, if I could trouble your lordships to turn up again in the supplemental bundle, tab 4. My lords, this contains 2 things. It contains extracts from the big Luton contract, 2004, and then later on at tab 12, one gets the Luton deed of variation. One needs to read them together. Starting in the 2004 contract, if we could turn on in this bundle, please, to page 103. This is the specification, purpose of the contract. A number of purposes are there listed. The one I'm particularly interested in for current purposes is at page 104 at the bottom. Which is that FCCR was retained to meet the statutory stroke recycling and composting targets and to comply with the diversion targets set out in the landfill directive. So what FCCR was being asked to do was effectively help Luton comply with its obligations as a WDA. And one can see that at the bottom of page 105. When one sees in the helpful box the overall objectives of the contract. In terms of the construction activities, FCCR was required to upgrade the transfer station at Kingsway and a civic amenity site at Eaton Green, and to build an entirely new civic amenity site at Progress Way. Civic amenity sites, my lords, are those sites where one turns up in one's car and disposes of one's waste. The point about the construction under these sorts of contracts, as we see indeed with the Greatmore contract, is the contractor pays for the construction up front and then it recovers its costs of doing so throughout the life of the contract.
The contractor does.
Yes, my lord. Yes.
In our case, it's the council who really does.
No, what happened in this case was, in fact, the contractor paid up front, and then the council, once the works were completed, reimbursed the contractor for 85% of the construction costs. But the contractor retained 15% of the construction costs, which then are just amortised over the remainder of the contract. And in Luton, what happens is that the contractor carries out these construction activities and then the costs are amortised over the entirety of the Luton contract. And obviously what that means is that although it's not possible to identify with precision, every time one receives a bit of the unitary charge, a bit of what you're paying for is the cost of the constructing of the facilities up front. In terms of the operational activities, FCCR was to manage Kingsway by segregating Luton's waste into 3 sorts of categories. And one sees that at page 107 and onto the top of 108. And so one can see that the waste was to be segregated into that which would be recycled, that which would go to composting, and that which would go to the final disposal facility. At the point in time that the Luton contract was executed, the final disposal facility was a landfill site. As to how FCCR will be paid, that was to be paid for by reference to what was called the unitary charge, dealt with in clause 34 of the underlying contract at page 86. Clause 34 refers in terms to the specification, which is the relevant point for the court's reference, and that's at page 130.
Sorry, so you gave us a reference before that. What was the earlier reference?
Yes, I'm so sorry, my lord. I'm just conscious of time. That's
Yeah, no, I
clause
see that.
34. It's
Clause
supplementary bundle,
Yep.
tab 4, page 86, my
Yeah,
lord.
thank you very much.
And that just kicks one into the specification.
Yes.
A bit like our contract, series of calculations required. In particular, at paragraph 5.4 on page 131, a base payment. Again, like our contract, it's calculated by reference to number of tonnes of waste processed and a price per tonne, which is fixed here in something called Appendix K. For the court's note, if you wanted to look at it, it's at page 170 of this bundle. And then, in addition to receiving the base payment, FCCR was also entitled to recover or get repaid the sums which it had paid out by way of landfill tax. And that's at clause 5.5. The landfill tax being incurred as a result of the disposal of the residual waste. And then finally at 5.6, the unitary charge included what was called the target bonus. And that was where FCCR effectively exceeded the recycling targets set under this contract. And I'm not going to go, but one can see what it's trying to achieve. In 2015, that contract was varied, and as I indicated a moment or two ago, one needs to turn to tab 12 in order to find the variation. The residual waste, which is the waste that remains after those segregation activities have taken place, and which had historically gone to landfill, is now to be delivered to one of 2 treatment facilities. And one sees that at page 403 at tab 12. The authority, and I'm looking now, my lords, at clause 5, diversion, notional payment and related provisions. And effectively, as your lordships will see from clause 5.1, in order to save the authority landfill tax, the contractor was now obliged to divert residual waste from landfill to either the EFW facility, that's Greatmore, or the RDF facility. RDF is a facility which effectively takes waste and turns it into fuel, which can then be used for generation of electricity at another site. Clause 5.2 is also of some significance.
because it provides for an entirely separate payment regime for waste diverted to Great Moor. And the court can see that if it looks at 5.2a. Just for the court's note, the revised pricing mechanism introduced by this deed of variation also reduced the baseline payment, which FCCR was to receive by way of the underlying unitary charge. Now, it is common ground that FCCB has already included the full amount which FCCR receives from Luton by way of the diversional notional payment in the TPI calculations that were carried out at the time. It's also common ground that Buckinghamshire did not seek declaratory relief from Mrs. Justice O'Farrell in relation to the question of whether the unitary charge payable under the 2004 contract was third-party income. Indeed, it didn't seek to include such a claim until December 2023. The judge concluded that the unitary charge was income which should be accounted for, or the relevant proportion of it was. He adopted BC's case that because 44% of waste from Luton ended up at Great Moor, so Buckinghamshire should be entitled in principle to 44% of the unitary charge, in addition to the entirety of the diversion payment which it's already received. The judge accepted that it was not possible to allocate the unitary charge to services which might be said to relate to Great Moor. And of course, one can see why that is necessarily so in the light of the nature of the facilities, that the services that I've just described to the court as FCC are providing to Luton. However, he said that notwithstanding that he couldn't identify any specific part of the unitary charge that might relate to waste that ended up at Great Moor, FCCR couldn't rely on the indivisibility of the charge in order to prevent its inclusion in the TPI calculations, because he said it was FCCR who had chosen to enter into a contract of this nature. Now, just pausing there, FCCR, of course, entered into this contract in 2004. And it did so on terms which were specified by Luton. And it's fair to say that FCCR didn't really have any choice in terms of the way in which Luton had chosen to organise its payment regime. The judge also characterised the solution proposed by BC, which is because 44% of the waste ends up in Great Moor, we're going to have 44% of the unitary charge. in addition to the diversional notional payment. He characterised that as a rough and ready solution, which he said was not manifestly unfair to FCCB. And one can see that from the judgment at paragraph 308. Paragraph 309, he notes that it's not possible to ascertain from the unitary charge the income actually generated from Luton derived from the TPI, and indeed that there were insurmountable difficulties in doing so. Now, I want to make a number of points about the judge's approach. Firstly, the judge is quite rightly not relying here on the natural and ordinary meaning of the words associated with the project, insofar as those words ever have a natural and ordinary meaning. He's not relying on that to find that the unitary charge income should be included as TPI. And what he's doing is fashioning for himself a manifest unfairness test. Which we say is not a test which finds any reflection in the definition of third-party income. Now, when one moves away from the natural and ordinary meaning, again, one is thrown back on asking what the purpose of the TPI sharing regime is. And as I indicated when I took the court to WIDIP a moment or two ago, certainly what WIDIP envisaged was the sharing of income generated from process outputs. Whatever else the unitary charge is, it is not income from a process output at these facilities. What the judge does is he relies on the Mrs. Justice O'Farrell decision in the Part 8 proceedings. Now, that decision was a decision taken in the context of two entirely different sorts of contracts. The contracts which were before Mrs. Justice O'Farrell were the North London Waste Authority contract, which I've spent some time with the court today, and one of the contracts which FCCW had with Hertfordshire. She did not have a multi-services type contract of the sort that Luton represents before her. And one can see that because what she talks about, in particular in paragraph 84 of her judgment, is ancillary activities related to waste that ends up in Greatmoor. Hence why it is she's concluding that haulage income is income which should be included, because that's an activity which is ancillary to getting the waste up in Greatmoor. However, there's a world of difference between the ancillary activities of the sort which Mrs. Justice O'Farrell concluded generated income, and the sort which are in contemplation under the Luton contract. And the other important thing about the judgment of Mrs. Justice O'Farrell is, as the judge in this case notes, Mrs. Justice O'Farrell didn't have the issue about costs before her at all. And in fact, BC's case is that it is entitled to 44% of the unitary charge, in addition to the diversional notional payment, but that FCC is not entitled to deduct any of the costs which it incurs in running the Luton contract, because it says those costs are not directly incurred and or they don't meet the provisos. In extending income to the unitary charge, the judge by necessity allows BC to recover income which is not ancillary to this project. And one can see that if one thinks about, for example, the construction services that FCC are agreed to provide, and the fact that 56% of this waste is in fact being recycled or composted. And in those circumstances, we say that the proper approach to the construction of the Luton contract, as varied by the 2004-15 Deed of Variation, is, if one looks at paragraph 5, clause 5.2 of that Deed of Variation.
Sorry, let me just go back to it.
Oh, I'm so sorry, my
No,
lord.
I put it away, which was
No,
mistake.
it's my fault, my
It was
lord.
tab 12, wasn't it?
It is, my lord. Oh, yes. It is at page 403.
Yeah.
The income which is associated with this project is the diversional notional payment, that being the sum which Luton pays to have its waste treated at Greatmoor. That is the only sum that anyone can identify with any confidence is income associated with this project.
Can I just think around that for a moment? So as you point out, 5.1 says the amendments are made to save landfill tax. I don't know how the landfill tax compares with the diversion notional payment.
Well, I can tell your lordship, I think the landfill tax at the relevant point in time was around £90 a tonne. And what happens with the landfill tax is that it goes up in a very steep curve to... Whereas the diversional notional payment was about, in fact, one can see it, my lord, if your lordship turns on to page 472 behind tab 12, actually maybe starting at 471. My lord, I do apologise, I should have actually taken your lordship to this. This is the pricing mechanism which applies following the Deed of Variation. And one sees at 5.5a the reference to the diversional notional payment. And then at the bottom, one sees the table which goes on from 471 over to 472, which is divided into periods and by reference to the cost for the RDF and the EFW. And your lordship will see at the top of 472 the price per tonne to be paid by way of the diversional notional payment.
So these are, that's the 73.42.
It is, my lord, but if your lordship just looks down at 5.58.3, as is the case with all of these
They're
contracts, they're stated as 2013 price, and then one index is up.
Yes, that's
And just while I was on 472, one can see that there are also provisions for payment or for ensuring that, as between Luton and FCCR, there's a reckoning between the amount that FCCR proposes to send to Great Moor or the RDF and the amount which it does actually. So it gets penalised if it doesn't send as much as it has said it was going to send. Now, whether one describes that as a burden of proof point, which, as your lordships will know, is also my ground 3, ground of appeal, or a construction of the term associated with the project, in my respectful submission, BC has come nowhere close to showing that the unitary charge is income associated with this project. For which account is to be given under these TPI sharing mechanisms.
And can I just take it a stage further? Suppose that one could say, well, the unitary charge is mostly about entirely different things, but suppose one could say, as regards some tiny bit of it, it isn't about those other things, it's about Great Moor. Mm-hmm. What would your answer be then?
My answer would be that one has to fall back on the way in which this charge is paid under this contract. And it is a charge for the services, for the entirety of the services.
I mean, that potentially isn't such an attractive position, because that answer would apply even if the bulk of the charge were attributable to Great Moor.
But my lords, firstly, the Buckinghamshire is getting the entirety of the diversional notional payment fee for a start. So for all of the waste that ends up in Great Moor, it is getting the rate set out at page 471 to 472. As matters transpire, this unitary charge is not reflective of the majority of the services being provided which are associated with Great Moor. The reason that I took the court to the purpose of this contract is that it's a unitary charge paid in order to allow Luton to discharge its statutory obligations. That's what Luton is paying for. That has got nothing whatsoever to do with Great Moor.
Well, is that so clear? I mean, its statutory obligations are now being discharged in part by sending the stuff to Great Moor.
And Buckinghamshire is having the income that comes from that.
But that sort of goes, we go around in circles. I mean, so if it were the case that some part of the unitary charge could be said to be for Great Moor stuff, you would still say, well, the council can't have any of it.
Well, how is one, I mean, in circumstances in which the judge has concluded that there are insurmountable difficulties in identifying a sum which forms part of the unitary charge which relates to the services, then in my respectful submission, those are the difficulties that Buckinghamshire faces, I'm afraid.
Yeah.
And my lords, for all of those reasons, we would invite the court effectively to accede to the grounds of our appeal and make the order we request in our appellant's notice.
Can I just remind myself what order you do request in your appellant's notice?
We'll all remind ourselves of that, my lord. It is, my lord, in tab 2. We're asking for, effectively, what the judge did is he, having concluded that we were not entitled to deduct any costs and that Luton income was to be included, I'm so sorry, it's not tab 2, it's tab 1, and it's page 8, my lord.
That's the bit you want to appeal against.
Oh, I'm so sorry, my lord. It is, sorry, it's page 10.
It must be 10, yes.
I've been on my feet all day.
Yes. Yes, I see. So the unitary charge falls out and you're not liable to pay the sums attributable to the
To the costs,
deductible
which,
costs.
absolutely, that sum being the costs which the judge had found we were not entitled to do.
Yes, I find.
Unless I can assist your lordships any further.
I don't detect any more questions, so thank you very much, Mr. Parker. Mr. Mort.
Good afternoon, my lords. I only have a relatively short period this afternoon, so I was proposing to address the factual context of the dispute. I appreciate that the dispute is obviously post-contract, so its assistance in construing the contract may be limited. We nonetheless suggest that there is a lot of assistance to be gained from seeing how the parties operated the contract and how this dispute arose, and the sorts of cost and income that FCC claim to have incurred. And I think we would suggest that when you understand how FCC operated the contract and how they sought to shield their income from my client before the decision of Mrs. Justice O'Farrell, and then sought to apply costs to, again, shield that income from us, it immediately becomes very obvious why these provisions are there and why the parties departed from the more simple reference to just marginal costs, and, for example, by adding reference to affiliates. In addition, obviously, my learned friend puts immense weight on what she refers to as the what would be a commercially balanced reading of the contract, and in turn, she accepts that the ordinary meaning of, for example, directly incurred is against her. So she puts great weight on how, in practice, this has all worked out. So again, we seek to rebut that analysis by reference to the actual facts. So, my lord, I want to just speak in the half an hour available this afternoon about the types of income and the cost arising and how the dispute developed. As a preliminary point, I must say, because my client will very much want me to say this is not a PFI contract. There were numerous references in the phone submission to cases, for example, you said this is another PFI contract, or when she's referring to the guidance notes, you're saying this is a PFI contract. This is a contract that has some features in common with the PFI contract in terms of its nature, and it's a contract with a local authority. But arguably, the defining, or one of the defining features of a PFI contract is privately provided finance. My client paid for this project, or 85% of it. It's an enormous achievement for taxpayers of Buckinghamshire Council, their representatives, to build this extremely profitable, or potentially profitable facility as a way of both disposing of Buckinghamshire waste and generating potentially huge third-party income. And so, again and again, when one looks at the various documents relied upon my learned friend as factual matrix, they're all referring to a PFI-type contract. My clients take inevitably, well, we've paid for this. We're not going to be treated in the same way. We're not going to have an arrangement for income sharing that corresponds with an ordinary PFI situation. So in terms of the income, if I can start with the guaranteeing of third-party income. So my learned friend made a number of references to paragraph 11 and the way in which the different components of third-party income
In the contract,
sorry, Lord.
in the project agreement.
In Schedule 15 of the project agreement, quite so. And we accept there are obviously different types of income that can be generated. In so far as third-party waste is concerned, there are going to be 3 or so types of income. There is gate fee income paid into the project, paid to FCCR or paid by FCCR to FCCB. And then there's gate fees paid by third parties to FCC Waste Services.
Sorry, gate fee.
So when we look at the 3 contracts...
Oh, to FCCW, we're calling it, are we?
It's Waste Services is what it's called, FCC Waste Services. My own friend referred to it as FCCW.
Yes, that's it.
But it's FCC Waste Services. And for 2 of the contracts, they're paid a gate fee for Greatmore. It's nothing else. They are paid a fee to dispose of waste at Greatmore. And so one of the issues that arises is, well, what if any difference is it make, whether it's paid to FCC Waste Services or to FCCR or to FCCB? And we say, well, quite obviously, it makes no difference whatsoever. The parties have anticipated the use of affiliates to reduce or to try to reduce income paid into the project, and the PA explicitly deals with that. And then the third type of income arising from third-party waste is going to be moving third-party waste to Greatmore, collecting it and hauling it by road or otherwise. And that's obviously not gate fee income, we accept that, but it's nonetheless income associated with the project arising from third-party waste. Now, in terms of the gate fee revenue, my Lord saw this morning that in the tender materials there was reference to FCCB or FCCR guaranteeing a rate per tonne. And that is another way of expressing third-party income from third-party waste. But whereas the base case refers to a sum of money over the 30-year project, the FCC also refers to that in terms of a rate per tonne. And as my learned friend mentioned just a few moments ago, the rate is obviously indexed, so it's different at different points in time. And the court should also be aware that there's quite a long interval between the tender and the contract being made, so that the rates used in the base case are already quite some years out of date. But the guaranteed rate is of the order of £66 per tonne as of September 2010. And as we'll see in a moment, that's risen quite a lot by the time we get to these 3 contracts being let as the third-party waste contracts. And
Sorry, that was as at something in 2010.
September 2010, we think it is, certainly 2010.
Yep.
When the tender is first put in, contract's not made until April 13, project's not open until June 2016. Obviously, in that time, the rate is going up with indexation. And what we want to propose, which we'll see when we come to look at specific documents, but that rate of £66 per tonne in 2010 is clearly below market rates. We see that because when we look at what North London or Herts were paying, they're paying £79 or £80, so £89 or £90, compared to what is by then about £77. So the situation as Buckinghamshire Council sees it, as of the time of the PA, is we are paying for and building this facility. You've committed to an extremely low rate per tonne. It will be very easy to get market rates for that capacity without any additional cost or work on anyone's part, simply using the contractual relationships or contacts that the FCC group of companies has. and therefore for every tonne of third-party waste disposed of at Great Moor, there will be a very significant margin of profit. And in our mind, a fair allocation of that margin, what the parties agree, is that we're going to get 75% of that, so a huge proportion of that profit, but justified in our minds for what it's worth on the basis that we've paid 85% of this facility. The contractor is nonetheless left with an incentive because they still get 25% insofar as they can beat the guarantee rate. And so that's what that addresses the requirement that the contractor is incentivized. But that's what most of the third-party income that we're arguing about and the cost it relates to. It's simply that third parties are paying a much higher rate than the guaranteed rate. And FCC is trying to reduce the income share by saying, for example, we have an extremely expensive head office in Madrid, or we have management, or we have back office, or insurance, or site costs. And we want to diminish that margin so that, in fact, the TPI to be shared is zero. And that's why we say, no, just look at how we've rejigged the third-party income definition. It's only cost directly incurred, and it's got to be specifically and solely, and so on and so on, because it would be all too easy for FCC, like other waste companies no doubt before it, to reduce the TPI share to nothing by reference to costs incurred in Madrid or wheresoever. A further point that needs to be considered, it's slightly peripheral, but please note this. Obviously, the guaranteeing of third-party waste income is necessary because, as my learned friend very ably, if I may say so, explained, the contractor is recovering third-party income in part to meet its own costs, of the O&M costs, the costs of FCC operating the plant. But there's a secondary consideration, which is if the plant is short of waste, they won't. Not only will they not make the third-party waste TPI guarantee, but they also won't make the electricity TPI guarantee, which is obviously dependent on a throughput of waste. In immense quantities, there was a little confusion about what values are shown in the base case. As my learned friend corrects herself, they're thousands. So the amount of income that's guaranteed from waste is not 600,000, or it's £600 million over the term of the contract, so over £500 million sterling, but indexed up, so now a much greater sum. And then about half again is guaranteed of electricity. And again, from Buckinghamshire Council's perspective, we are looking at the PA in the base case. We have very limited visibility as to how FCC or the group of companies operate, or what costs they make, or how they recover their costs or their overhead and so on. But as a matter of common sense, FCC will have taken steps to ensure that they can deliver 600 million pounds worth of third-party waste and the related electricity income. And we suggest that in practice, that such huge quantities of third-party waste are going to come from other local authorities. I do accept my learned friend's point that, well, that's not necessarily what all the background documents say. And as reference to C&I, it was established at trial that in the waste industry, terms are used very indiscriminately. So C&I sometimes means commercial waste, but it's also used to mean non-contract waste. The correct meaning is obviously commercial and industrial waste. But the parties clearly anticipated the use of municipal solid waste. And the evidence at trial, and you can see that in Mr. Longden's statement, which I'll take the court to shortly, is that the plant runs better on municipal waste because it's of a lower calorific value. And counterintuitively, you want more fuel going into your plant because you will make more money that way. So the plant has a ceiling as to how much electricity you can make. You want lower calorific fuel to generate that electricity and maximise your So if we just briefly talk about the three contracts that FCC affiliates or FCCR entered into, what we have is some very helpful slides that were prepared by FCC early on in the project history. They're in the supplementary bundle, tab 46, page 917, so very near the back. So at this point in time, GOMB refers to a liaison committee. This was their second meeting. The contract was from 2 years earlier, from April 13. The project is going to become operational in June 16. And at this stage, FCC was reporting to Buckinghamshire Council the success they had achieved in procuring third-party waste by way of these three contracts. And they had done this without reference to Buckinghamshire Council, so they were telling us after the event what they'd done. And the three contracts are those that my learned friend has referred to, namely with North London Waste Authority, Herts Council, and a variation to an existing contract with Luton. And this was going to supply a huge proportion of the waste that was necessary. And what we had in these slides is an explanation of what's being paid by the third party versus what's being paid into the project. If we just start with the first one is Luton, you see the calculation on page 921. Now, the most important...
Sorry, I wasn't keeping up which page we're on.
I'm so sorry, my lord, 921.
Yes.
So it's the couple of slides in. The first contract, Mr. Sinclair addresses Luton. And what you see in the middle of the page, guaranteed third-party waste income. These are prices per tonne, as you can see indicated at the top. And this is the guaranteed rate, which was £66 in 2010. As a result of indexation, is now £75.97. What my client is expecting is that we're going to be able to get rates higher than the guaranteed rate and share the difference. And what FCC is explaining is, well, actually, that's the rate that this client is this third party is going to pay. So there'll be nothing to share. And there's reference to overhead and margin. This is on the Luton contract, captured in the wider contract. In other words, the profit, and there is immense profit on this contract, the profit for Luton is in the unitary charge. So Luton's going to pay exactly the same to the penny as the guaranteed rate. Instead of sharing the extra, because there isn't any extra, the profit that's made from this contract is going to be kept by FCCR. This is obviously long before Mrs. Justice O'Farrell's judgment. If we turn to the next one at page 924, the next equivalent analysis, these were a spreadsheet converted into slides. And here we see a slightly different story. The third party, as you may recall from Marlene Friend's submissions when we looked at when she took the court to North London Waste Authority contract, the rate that they pay for disposing of waste at Great Moor is £90. But bizarrely, the rate that's being paid into the project is, again, £75.97. And that's a like-for-like comparison. We'll look at the contract in more detail probably tomorrow morning. But this is a fee for paying for waste to be disposed of in Great Moor. That there should be absolutely no difference between the rate that the third party is paying and what is then shared between FCCB and my client. But what FCC is doing is they're trying to justify why there's a huge difference. The most significant difference being group corporate overhead, 5.7%. That's not a percentage that we ever see again. Where it's come from, nobody knows. I refer to my earlier comment that when we see how this dispute started to develop, this is the contractor and its associate companies, affiliated companies, applying what appear to be generally indirect costs in order to diminish TPI calculation. So they're saying we've got a huge overhead that we have to pay. And they don't maintain this figure anymore because the figures have changed a number of times, but they still maintain the principle. We're allowed to deduct overhead. We'll look at the actual deductions they make, but I can't resist just making an important point of principle here. The court will note that the overhead calculation by the 5.7% is being applied on the entire gate fee. It's not 5.7% of the additional gate fee being paid by the third party to waste services. FCC is saying, well, we need to get our overhead from this project. So we're applying 5.7% of all of the gate fee, in other words, the guaranteed gate fee, and the additional bit element that is over and above the guarantee. So we say, well, when Mr. Langdon or Mr. Mackenzie said, well, we've got all these costs, so this isn't working for us. What they mean is they anticipated when they went into the PA that they would always be able to diminish third-party income by applying these indirect costs. And if we just briefly look, I think while we're on North London, we will have to briefly look at what my learned junior patronisingly referred to as my favourite document. If we could just look at page 879, sorry, 879, tab 43. So this document was disclosed by the defendant, by FCC, relatively close to the hearing with their witness statements. And it's an internal approval document of the North London Waste Authority contract. And it's only an extract because we were trying to get the bundle as short as possible. But the key bits are, there's two versions of this document. This is the original version. Section 6, Economic and Financial Projection. I think at this stage they have in mind the £90 a tonne. And the author of this document has said under 6.1 key assumptions, second paragraph, the price for Great Moor energy for waste has been modelled at the rate shown in section 6.2 below. This assumes the base price, in other words, that's the guaranteed rate, for the Great Moor project of £77 per tonne as of 15/16 indexation, with a profit split on the remaining gate fee of 25% to FCC to be retained within this project and 75% to Buckinghamshire County Council. And so what we said, well, we guess that's exactly what's supposed to happen. There's a big difference between what the third party is going to pay and the guaranteed bid. The extra over should obviously be being shared with us getting the lion's share. But that's not acceptable. Obviously, we weren't privy to any of this until last year. And then if we turn over to if we just look at the little table at page 882, and you'll see that there's reference to Buckinghamshire Council rebate at Great Mall. So we get 75% of the difference between 90 and £77.
Sorry, where are you?
I'm so sorry, my lord. Page 882 is a
Yes.
table summarising, and there's a column headed Great Mall, which is the penultimate column.
Oh, yes.
And it's the comparison of 90 and 77.
Yes.
It's referred to as break-even price, but I think they mean the cost to FCCR, which is the guaranteed rate. And we're saying, yes, this is exactly what should be happening. We should be getting 75% of the additional additional fee, because there's no cost involved in this part of it. It's literally just disposing of waste at Great Mall. That's what the third party is paying for. And my lord, then that was from, I think, 4th of September, and there's an email at page 883 of the 10th of September. And the author, I think also the author of the report we can see from 879, Katie McPhail, did not give evidence at the trial. She says, like, I've done an updated approval paper for North London. I'm looking at the bottom email on 883. Section 6, financials have been updated to take into account the following. All profit for Great Moor above the £77 per tonne base case remains with FCC Waste Services, or FCCW, as I don't know if I'm refer to it. And then at page 889, we then see a revised version of that same table. And there's only so much to be got from this, and we're not. There's no pleaded case of FCC doing anything improper or anything of that kind. The point is, it illustrates so clearly exactly the sort of problem that a local authority has, and how easy it is or would be for a large waste conglomerate to identify costs such as overhead, whether they be local overhead or head office type overhead, come up with a proportional percentage and apply it in order to diminish the third party income.
Is that going to be a good moment to stop, or
Yeah, I'm
not?
very happy to do so, my
Yes,
lord.
let's do that. So 10:30 in the morning.
All right.